Welcome back to City Education, your home for education in all forms, shapes, and sizes. Today we dive into a very fascinating aspect of intellectual property. We'll be exploring unlawful competition. We'll break down what it is, its various forms, the legal frameworks that govern it, as well as that
cases that
deal with it. Now let's get into it. So what is unlawful competition? In South Africa, the Constitution under Section 22 affords everyone with the right to freedom of trade, occupation, and profession. The right encourages healthy competition among businesses and service providers, which is good for the economy and prevents monopolies. However, the right is not absolute and has limitations, such as needing the necessary qualifications for a profession. So, when does competition become unlawful? Any form of competition will naturally pose a threat to its rivals in business, but not every competition is considered unlawful. Competition only becomes unlawful when it is deemed wrongful. As stated by Langa CJ in the case of Phumelela Gaming in Leisure Ltd
versus
Gundling in 2007, only when competition is wrongful does it become actionable. Unlawful competition can thus be defined as actions by individuals or businesses that undermine fair competition, harm competitors, or involve dishonest practices. It occurs when a trader commits a wrongful act that causes or is likely to cause damage to a competitor by interfering with their right to custom. Now let's look at the Aquilian action and its historical context. Now, an action for unlawful competition
can be pursued
or Aquilian action or actio legis aquilia, which is basically a remedy for damages caused by a wrongful and culpable act. The elements
for this intellectual claim
are a voluntary act or omission, fault, culus and culpa, causation, damage, and unlawful or wrongfulness. Basically delictual elements. Now, historically, this is not always the case. However, modern South African law recognizes action for unlawful or unfair competition as a form of Aquilian remedy. This was affirmed by the Matthews v. Young case, where a court recognized that the Aquilian action may be invoked where patrimonial loss is caused through unlawful competition. The court stated that while a person is entitled to free exercise of their trade, the competition must remain within lawful bounds. An interference with the riot would constitute an injuria for which an action under the Lex Aquilia lies. The general action was further recognized in Dun and Bradstreet v. South African Merchant Combined Credit Bureau, which is a 1968 case, where it was stated that the broad basis of the Lex Aquilia is available for the recognition of rights of accents even way there is no direct precedent. Moving on, let's look at the types of unlawful competition based on statutory prohibitions. The first prohibition is parallel importation. Now, this occurs when a trader imports a product into South Africa that is already available here and goes on to sell it at a lower price. Generally, parallel importation is not unlawful unless that importer does not comply with regulatory requirements of the product. These include acts like the Consumer Protection Act 68 of 2008 and the Liquor Products Act 60 of 1989. The case of Taylor and Horn, this is dental, is an example of this. Now, the second prohibition is false
description. This is
specially prohibited by the Consumer Protection Act 68 of 2008. Section 4 of the Act states that a person must not knowingly apply a trade description for goods that is likely to mislead a consumer. It is also unlawful to alter, deface, or remove a trade description or a trademark in a way that is calculated to mislead a consumer. Thirdly, we have prohibited emblems and marks. This, for example, is covered under the Merchandise Marks Act 17 of 1941. This act prohibits the use of emblems and marks that it could mislead consumers about, for example, the geographical origin of a good. Fourthly, or finally, we have ambush marketing, which comes in two ways. Ambush marketing occurs when a marketer promotes his products or brand by using a protected event as a platform without paying to be a
sponsor. It takes two forms.
as I've mentioned. Firstly, ambush marketing by association. Now, the marketer here gets the public into thinking that they are an authorized sponsor or associated with the event. They can do this by using insignia that is confusingly similar to the event. Now, the second form of ambush is intrusion, basically ambush marketing by intrusion. Here, the market gives exposure for their brand through the publicity of listed by the event without the organizer's authorization. For example, by placing product advertisements just outside the stadium where the sponsored event is taking place. The case of Heifericus Metcash Trading Africa TQI Ltd deals with this type of conduct. Ladies and gentlemen, we've come to the end of this brief introduction into unlawful competition. We hope this video was impactful to you, and we hoped to see you again in our next one. Don't forget to like, share, and subscribe. This is
City Education.
your home for education in all forms, shapes, and sciences.